to Crouch.
Madam Chief Justice, Your Honors, good morning. My name is Andrew Crouch. I represent the appellant defendant, Gilberto Torres, in his appeal from 2 convictions out of the Hampden County Superior Court. This case, as Your Honors will note from the record and from the decision of the appeals court, involves some very unusual and unfortunate circumstances, especially relating to a single juror who is referred to as the problem juror in the appeals court decision, juror number 14, whose unusual behavior starts as early as the defendant's closing argument and continues through all the way through to reverberating through the deliberation.
Mr. Crouch, because the defendant, through his attorney, was objecting to the discharge of that juror up until the very end, I mean, isn't it an impossible situation for the judge to do other than...
I think that where we can start here and what simplifies the court's review a little bit is the Connor decision. And I think Connor makes clear that any interaction with a juror in terms of deliberation is going to be fraught with peril, and it needs to be, judge needs to tread very lightly. And what the court directs in Connor is that any time that a trial judge receives a note from the jury room, caution needs to be adhered to. And the first step needs to make a determination as to whether or not that issue is personal to the juror or has something to do with the actual deliberative process. That is the exact first step. And also this court in Connor went so far as to suggest
Didn't the judge do that? I mean,
Yeah.
it's fraught with peril because you never know what's going to be blurted out of someone's mouth. So didn't the judge do whatever he could do to try to do almost exactly what Connor was saying?
I think what
And made determinations?
I think in terms of the actual interviews, the court in Connor says in most cases it may well be a mistake for the judge to conduct a personal interview based upon messages of alarm from the jury room unless those issues are personal to a juror. What the judge does here, and I think where the first misstep is conducting a personal interview not with any particular juror but with the foreperson, as opposed to what happened in contrast in Swofford, which this court upheld. In Swofford, what the judge does instead is when he gets a similar message from the jury room, he sends a message back with essentially a yes or no. Is this issue personal to the juror? When he gets a no response, he tells them to continue deliberating. Here, instead, this is sort of an inevitable result.
So the defendant agreed to this procedure. It was an effort to try to figure out, to sort out what was happening in there and to determine whether there was a personal element to it or something more.
Correct.
And then agreed to that procedure.
I agree, yes. And I think it's the personal interview is where this starts to go a little bit wrong. And I think the best step there is to follow Connor, send a message back, follow the advice from Swofford, send a message back, determine if it's personal or not personal.
Well, with all due respect, if I was a juror and not a lawyer, and I got a note back from the judge saying, is this problem personal to the juror, I would say, what does that mean?
I think that it can be directed as to what Connor talks about is whether it has to do with any issues divorced from the deliberation of the case. And I think that the judge's note in Swofford got the exact response that he was looking for. And there are similar issues in Swofford. But what happens specifically is he gets the response back that no, actually, it's not personal to a juror. It actually has to do with essentially with the deliberation process. When you get the answer no, judge says continue your deliberations, move on. Any subsequent issues can be further addressed, but the first step needs to be just sending that message back to the room. Instead, what we have here, we have this interview which doesn't even directly relate to the juror in question, but instead relates to the foreperson, and we get this inevitable flow of inside information that the judge himself notes. I've learned information here that I certainly that I should not have been aware of. And the deliberative process at that point in the jury room has been breached. What we have then is a continuing series of events where we learn more and more about what actually happens in the deliberation room. And the real key problem with that, which is talked about in Connor and it's talked about in Hebert, is that after you learn of the internal deliberations of the jury, there is inevitably going to be, as this continues, some sort of subtle coercive effect of continued conversations with the juror. So here, where we have, where Hebert suggests that, or where Connor suggests that these points could be demonstrations of juror deadlock, Each of these instances could be instances of juror or evidence of juror deadlock. What we have is, as the judge continues to speak with the juror, more and more the juror is getting this subtle view that, being the holdout, being a lone minority view on this jury, that the juror doesn't have the right view. And eventually, this person, the district attorney herself, as early as the second note, says, I'm concerned about this juror, that her desire to leave is so strong that she would say anything, guilty, not guilty. It's as if she doesn't care. This is very early on in the process. What we have then is it continues on and continues on till we get to the point that we are in the actual global poll of the jury. The judge himself knows that this juror has caused problems before and needs to keep an eye on him, and to the judge's credit, sees the juror not say one word during the global poll of the juror, asks the juror specifically, juror says not guilty. It is at that point that we're seeing the motion for the mistrial. It is at that point that sends the juror back yet again. No further instruction, no Tui Rodriguez or anything like that. Instead, what we have is, as I note from Connor and Hebert, there is a subtle coercive effect that happens once the deliberative process has been breached. I think that Hebert offers a good example of showing what happens when the court doesn't know the views of a jury. Or Swofford's another example. Swofford, they didn't know which way the juror's view was. Here, we had clear indications very early on that the appeals court correctly notes both sides may take strategic points of view on, but we know very early on what that juror's view is.
But Mr. Crouch,
Well, at one point we know the view seems to be not guilty. Then at another point, the juror says, I want the truth on the paper. Then at another point, it sounds like the juror's saying guilty.
And then comes back not guilty.
So it's ambivalent.
I think that it's at first we see that there is disagreement both from the foreperson, saying that this is, that this person is not agreeing, and the foreperson says it's not a coherent or logical manner of deliberation because potentially, that foreperson disagrees with the viewpoint. And then she does say she's trying to be impartial, but she says, even in the personal interview with the judge, that she doesn't agree with it, that she doesn't agree with the evidence. And she goes, eventually acquiesces to the point where they can come out to the courtroom to announce a verdict, and it's at that point she again says, not guilty. And then 33 minutes later, after being sent back yet another time, finally acquiesces and says guilty. But there is concern, as Your Honor notes and as the district attorney noted, from the very earliest stages that the desire to leave also could have been so strong that the juror could have been swayed guilty, not guilty. And then eventually, for whatever happened in the deliberative process, that juror maintained a minority point of view of not guilty until eventually this came into play and the juror acquiesced. That, coupled with the judge's failure to follow the Connor protocols, is what raises this. This is a very unusual case. These circumstances are highly unusual.
well,
as
in
the appeals court noted.
Connor, the judge did discharge the juror, and the problem that the court said was that could have been the lone holdout, right?
Correct.
So, I guess if the note comes from the foreperson, as it did, that is describing points of view articulated by juror number 14, and you say the response should have been a note back saying, is this problem personal to the juror, or does it relate to your deliberation process? And presumably, or certainly it could have happened that the foreperson would have had the perspicacity to say, yes, it really relates to the deliberation process. Okay. So they continue. I guess I'm just not sure what, you've got the same risk. I mean, it's clear from that note, or one could infer from the initial note, that there's an issue about this juror not agreeing with the rest of the jury.
Well, it's important to keep an eye on what the exact language was of that first note, and it had to do with that this juror is unable to deliberate in a coherent and logical manner on the issue. At that point, we don't necessarily know what the answer is, and there may very well come circumstances in a future case where the first note from the foreperson or from the jury is such that it lays out the deliberative process. That didn't happen here. It also didn't happen in Swofford. We may, view from that forepersons have the understanding and the discretion to, at least with the initial note, not lay out all that information, understanding the importance of keeping the privacy of the jury deliberation. But the first note is such that it's bland enough that we don't know what the issue is and we don't know what the point of view is. This could have been a holdout in a very different respect. The initial response is counseled by Connor, as counseled by Hebert, and especially in Swafford, is that response is not to suddenly interview the foreperson, because that is fraught with peril, and the peril was realized here. That what we have instead, it is certainly a difficult issue, and I think that part of the problem is that Connor's not even, this is sort of done very quickly. Connor's not referenced in the discussion at all. They don't take a break at all to try to do any research as to how to address this specific issue. Instead, the judge, probably looking to move the case forward and behalf of all the parties in the court, immediately engages with the foreperson, not just in a note but in an interview. And that was what was fraught with peril. That's where we started getting into the snowball effect and the failure to follow that Connor protocol, especially where the deliberative process then leaks out into the court. That's where we see substantial, we have problems. And these circumstances, I said, are one that led the dissenting opinion in this case in the appeals court to note that, that it was potentially one of exasperation. It's one of these circumstances were sufficiently unusual that we can't be sure that justice was done and that the preservation went into the defendant's right to the fair trial. And I think that is the main issue that the defendant has here on the appeal. It's also, I would just note that Massachusetts law suggests that in terms of this issue of deadlock, that the jury should not be sent out more than twice. That's General Law, Chapter 234, Section 34. I think there's potentially a legal issue here as to whether, how many times this counted jury deadlock. I would suggest that from the early stages, and the appeals court disagreed with me on this point, that deadlock is not necessarily the jury coming back into court always and just saying we are unable to reach a decision. We are seeing issues of deadlock from as early as the points with.
Talk about fraught with peril. If we are going to interpret or seek to interpret ambiguous messages from the jury as whether this does or doesn't constitute deadlock, I think we are in deep trouble.
I think that this doesn't need to go as far as reaching the issue of deadlock. I'm just merely suggesting that this is all part of the whole amalgam that this court needs to consider, and this is one of the notes of the appeals court, that it could have just been limited to the very last moment and just the consideration of the judge or the person saying not guilty at the point of the polling. But I think that we need to consider all of the evidence that happened from the very earliest instances of the hand being raised during the defendant's closing argument, straight through to the particulars of the discussions between the individuals, or between the foreperson, between the individual juror, and all of the discussions that happened in between. The final issue I'd like to discuss, and just briefly with the time that is remaining, relates to the accuracy of the measuring device. In this case, we had a Measure Master walking tool that was used. I would ask that the court take a look at specifically at obviously the case of Commonwealth versus Why Not, which from about 3 decades ago starts laying out some of the points with respect to accuracy and reliability. This is not one that has to do necessarily with scientific theory, but one that Why Not suggests that even in cases where the devices may seem relatively simple, that when you're looking to admit any sort of scientific or technological results into evidence, that it is indeed conditioned on a finding that relates to the accuracy of the specific device in question, that these devices might otherwise be admissible and might otherwise be reliable on a scientific theory or a technological theory is insufficient, that what needs to be done here is a specific demonstration. I would suggest that from the record there are sufficient questions to demonstrate that that necessarily was not the case, that this is something that is indeed the Commonwealth's burden, and until the Commonwealth's burden is met, especially where there's conflicting testimony between 2 separate sets of officers, that until that specific reliability factor is met, that the accuracy of the device remains in question under Commonwealth versus Why Not. I believe that should be extended to this matter to meet just that threshold determination.
All right. First of all, as we know, there's no objection here.
Correct. Yes, Your Honor.
Second of all, let me focus just for a moment on what Officer Reardon testified. He was the second witness. Did he testify that he had calibrated this device recently?
He said he had done that at some point earlier in the month. He was unable to specify any particular point.
Okay. So he testified he had calibrated it, and I assume that means you measure it against a known distance.
Yes.
And ensure that it's working accurately. And that he had previously measured this same distance. It had been more than 1,000 feet. So why isn't that enough? Just because he didn't understand the internal working of the mechanism,
Well,
why isn't that enough?
Officer Reardon, obviously not being the one who actually conducted the actual use of the device, first of all, there's a potential question about how neither of the officers could testify as to how the device was specifically worked. There was no demonstration of reliability on the day that it was used. Also, there was issues with respect to the suggestion that the distance was north of the location that it was actually that the measurement was done to. I think all of this
Isn't
comes.
this really fodder for cross-examination? I mean, that sounds to
I
me
think that is indeed part of it. I think that here, obviously, under a better standard review, we might have a different result. But with respect to the standard review that we have, I think reliability was not demonstrated, and I would just ask that why not be extended to this particular case.
Thank you, Mr.
Thank you,
Koch.
Your Honor.
Ms. Dillon?
Good morning, Your Honors. May it please the Court, Diane Dillon, an Assistant District Attorney representing the Commonwealth. I'd like to go backwards just for the sake of my own memory and address that last issue first. There was no objection, but it seems to me now on appeal, he's raising the reliability of scientific evidence. If that were the challenge, any kind of Lanigan or Dolbert challenge has to be pretrial. So not only was there no pretrial, there was no objection, and Officer Reardon did testify from his own personal experience. He had measured previously the distance from the Lafayette Club to that particular school, and it was under 1,000 feet. And in addition to that, the measurement in this case was 841 feet, which the appeals court, I think, soundly reasoned was sufficiently under the 1,000-foot threshold, so that when we're talking about whether or not there's a substantial risk of a miscarriage of justice, which is the appropriate standard of review, that doesn't come into play.
Did Officer Reardon also testify that he had recently calibrated that same device that was used?
He did, Your Honor. He said that he had recently calibrated it and that he usually did so by using a surveyor's tape of some sort. And that was within that calendar month.
Calendar month, you mean before?
Sometime within the month of May 2005, Officer
When it was
Reardon
being
had
checked,
personally
okay.
calibrated that very same device. And in addition to the fact that he calibrated that device, he had personally, at some point, we don't know when, measured the distance from that club where the transaction took place to the school in question, and that was under 1,000 feet. That's not something that's likely to change regardless of the time frame. Now, as far as the deliberating juror is concerned, which seems to be the primary issue of concern here, I'd like to first of all distinguish this from Connors, because in Connor, there were problems that crept up during the course of the trial, which the judge handled without apprising defense counsel of anything that was going on. And one of the things that strikes me in the decision is that when this juror was finally allowed to become one of the deliberating jurors, the court said this is something that was known before this person was a deliberating juror. So the case is distinguishable on that base in and of itself.
You mean the whole hygiene issue?
Not just the oral or any kind of
Whole,
hygiene issue.
whole, I didn't say oral. yeah.
It seems to me that for whatever reason in the Connors case, the fact that the mother was calling, there really was a psychological problem, and the judge found that there was a psychological problem, and he found that this juror was not fit to be a deliberating juror, and the court said, you can't do that on this record. There's just not enough information. And so the problem was when this issue arose after he became a deliberating juror, and the fact that nothing was done when the problem was becoming apparent to the judge, and apparently neither of the parties was aware of this problem with the juror. So I think that that's distinguishable.
Can I just ask you about
Yeah.
the piece, in fact, that was quoted in the appeals court opinion from footnote 5 of Connors, which was not, which is essentially is the orthodox approach would be decline to take at face value any message which does not describe difficulties which are personal to a juror and to treat the problem as one of a deadlocked jury.
Yes, and I don't quite understand that, because it seems to me that this didn't describe a deadlocked jury.
But essentially what the court, as I took it, was saying, not when you get a message from the jury that says, we want to have further instructions, when you get a message that says, we're having problems with a juror,
Yeah.
that unless the note is clear that it's personal, in other words, the court is saying you really shouldn't start to get into anything unless it's personal, treat it as a deadlocked jury.
But I don't see any more validity to treat it as a deadlocked jury than to treat it as personal. An inquiry has to be made so you know how to treat it.
Well, the problem is, and that's what happened here, is that if it's, and that's exactly the point of the court, if the note doesn't make, and we've had notes that says there is a juror who is, sitting in the corner and refusing to participate.
That's Wofford.
I'm just asking your view, because one of the things that happened, which clearly happened here, and then the appeals court had to deal with it, is the judge begins to get information that the concern is not personal to the juror, that she has, or is it, I don't know whether 14 is a he or she, has, very strong views about police conduct and so on and so forth.
Well, I think what happened, and it's very much like Swafford, didn't know what the problem was, so you had to make an inquiry, and the foreman was called in, and the foreman blurted it out. So this was inadvertent, but the judge didn't act on that at that point. Once he found out it had something to do with the deliberative process, he just sent them right back out. And he said, it has to be unanimous, give due weight to the views of other jurors, and he sent them out. There was no harm, no foul. Nothing more happened until the next two notes simultaneously came in. And at that point, it became clear that there's a problem with this juror. And it was the Commonwealth who said, I want this juror discharged. And the defendant said, no. Now, in Swafford at 336, it says, if the defendant didn't object, he's not entitled to relief at this point. And he did not object. It was the Commonwealth who said, this juror was not candid in voir dire.
But haven't we also said that it's, I understand, again, the appeals court said, it's not determinative, but it can influence a judge. I can understand why at that point the Commonwealth is saying, I want the juror dismissed, and the defense says, I don't, because it looks as though this juror is going to go one way and...
My way. Yeah. So the juror...
No,
didn't.
not your way. The reason why the Commonwealth wanted the witness off at that point was because it looked like the witness wasn't going to go that way. Perfectly appropriate for the Commonwealth to say, I want the witness off.
But the judge at that point dealt only with the problem before him from those questions, and that was the Commonwealth saying the juror wasn't candid about whether or not this juror would believe the police. So the judge voir dired on that and said to the defendant, do you want anything else? And the defendant said no. And then the Commonwealth said, I'm very concerned because this juror has expressed the desire to go home, and I don't want her will to be overborne by her desire to go home. Would you voir dire her on that also? And the judge did. And the judge found in the appeals court, in its decision said, as a matter of credibility, he apparently believed that she really would give it her best. And he sent them back out to deliberate. And that's all he was dealing with at that point, because the only thing before him was the Commonwealth's motion to discharge a deliberating juror. And he recognized the defendant has a right to be tried before the first impaneled jury. Then they said they had a verdict. And when they came in, the judge, who was alerted to the fact that this juror has posed some problems, you might say, was doing what the court said you should do in Lawson, citing Floyd F. He watched her, and although the other jurors in the informal poll did agree, she said nothing. So he specifically said, do you agree? And she said, not guilty. At that point, the jury was immediately sent out of the courtroom, and the judge said to counsel, Now what do you want me to do? At that point, defense counsel said, I move for a mistrial. He said, on what grounds? And the defendant said, because it's clear they're not going to be able to arrive at a verdict. Well, that was not clear at that point, Your Honor. The judge was correct in saying, you don't know that. Now, they've only been out for a few hours altogether at this point anyway. This is not a long, involved process.
If you look at this as a totality of the circumstances view, and you start with the juror, with the first note from the juror, and which says, I don't want to stay on the jury, not guilty. I want to go home. May I never go through this again. Now I got to home, guilty. So I bring in to go home. And you add the juror's comments to the court officer. Are you going to release me yet? I'm going home yet. And you add her raising her hand. I think it's a she. Raising her hand as the judge concluded his remarks. And then you add in the comments that the juror made to the judge when he asked the juror, is there anything in your mind that says you could not be fair to both sides? I've tried, yeah. I don't believe the true or the false. If you add everything in, isn't there an awful lot there that should say to the judge, you know, this is something that maybe with each step the judge was doing what the judge is supposed to do, but when you step back and add up the sum total, it's just bad.
Not only
Too
was
bad.
the judge doing what the law required him to do at each and every stage of the proceedings, he was also bowing to the defendant's wishes at each and every stage of the
But
proceedings.
that's not what a judge is supposed to do. A judge is not supposed to bow to the defendant's wishes.
I think that when the defendant said he did not want that juror discharged, the judge was required to take that into consideration.
I'm not suggesting he doesn't do that, but I don't
And I
think he
think that
bowed
when the
to the
motion for
defendant's
mistrial
request.
was made, the judge is required, when you're considering all of the options, to determine whether or not this defendant has an interest in having that case decided by the first jury.
Well,
And although there is
that
some...
may have been true at that case, but we've got an escalating situation. Let me ask you this. How much time elapsed between when the jury came back, said they had a verdict, the juror says not guilty, they send the person out for further deliberations? How much longer do they
I
deliberate?
believe that was 30, 45 minutes, Your Honor.
May I ask you this? I mean, one of the trial judge's conclusions was that the juror was impartial.
She said she was impartial, and that
Well, here's my question. Given what she said in her notes and her behavior with the court officer and her raising her hand and her ambiguity about whether she could be fair, do you think the judge's conclusion was accurate, that she was impartial?
I think that we can conclude that she's eccentric, but I don't think that we can question the judge's determination made while he was questioning her that he believed her when she said she could be impartial. And that the standard of review for an appellate court and reversing a judge's finding that that juror is impartial is something that the defendant hasn't met.
Could I turn to the piece of the appeals court opinion that goes towards the end that is dealing with the post-initial first verdict, or first verdict, if I could say that?
When they first came in and she disagreed? Is that what you mean, Your Honor?
Well,
Just-
it's from that period forward.
Thank you.
The judge also acted within his discretion in determining that in ultimately agreeing to a jury verdict, the juror's will had not been overborne by her desire to go home. Was there any colloquy with the juror after the full guilty verdict was reached, in other words, the second time around?
No, nor was there any request for
No,
one.
wasn't there
Your
an individual polling after?
Honor. There was an individual polling when the verdict
I just
itself.
am trying to find the basis of the appeals court that the judge, in determining that the jurors' will had not been overcome, the judge could reasonably rely on the jurors' response. I mean, how do we know the judge is determining anything here?
Well, first of all, he did voir dire her as to whether or not her desire to go home would overcome.
That was before
That was before.
she went back.
Before she went back, and he found that it would.
And what about if the juror's objective was to be released from jury service, which appears to have been the overwhelming objective here, wouldn't it more likely be if somebody got back into the jury room and said, you're never going to get out of here unless you agree with us?
If she really wanted to go home, I think the point of that was logically it would follow she would acquiesce and just go along with the first announced verdict that was not recorded by the court because she didn't agree with it. She would have saved a lot of time if she'd just gone along to get along.
Well, then she figured it out, and the second time
But she didn't.
after when she came back, she did.
She may
Right?
have been eccentric, she may have
No,
been
but the second time
confused.
around, she went along, correct? We got a guilty
But
verdict.
if she was trying to save time, she would have gone along the first time.
Yes, but then she figures it out. She is eccentric, and she figures it out. She wants to go home. In other words, I'm trying to understand the basis of the appeals court saying it's unlikely that she would. I mean, how do you conclude that she wasn't just going
Well, Your
along
Honor,
to get
based on this record, I don't think that either assumption is more warranted than the other, but
Oh, I
as a
quite
matter
agree.
of logic, if
Didn't,
you
don't
want
you
to
take
save
it from the
time-
polling, that the last point is from the polling? In other words, that she said her verdict was guilty and then she was polled?
She was polled, yes, she
But
was.
I quite agree with you, Ms. Dillon. I don't think you concluded either way. And I'm just interested on the basis in which the appeals court concludes it in favor of the Commonwealth.
Well, I think that it's written, too, as a matter of logic. If that were what she was trying to do, she would have saved everybody a little time if she'd just gone along the first time. But I don't think that based on this record, there is any information to warrant an irregularity there, Your Honor. Because the judge had found that she was willing to go along and she was interested in having the truth be on the paper, which I take to be the verdict slip.
Thank you, Ms. Dillon.
Thank you.